Hello, everyone. Good evening. Let's see. Yep. So good evening, Josh. Good evening, Patrick, and good evening, Janet. I guess we could begin, or should we wait for some of your fellow classmates? We could probably wait for 5 minutes more. Are you happy to wait? Ready to go? Okay, yeah. Why don't we start? Okay, good. So in relation to, because Janet asked a question about the recording of the previous tutorial session, unfortunately, I lost the file of that one. The reason for that is that after the session of Thursday 2 weeks ago, the recording was sitting on my desktop, not in a Dropbox folder, because I was meant to edit it because there was a portion there that, a portion of the recording where Patrick unintentionally showed or shared his screen, and he asked me to edit it, and I was planning to edit it on Friday. Unfortunately, my computer had crashed by then, and I couldn't retrieve the recording. So, but given the fact that you're done with the legal memo, I hope it wouldn't have been much of a loss anyway. So that's the explanation why we don't have the recording for the tutorial session 2 weeks ago. So we will proceed now. The focus of tonight's topic is on unauthorized decision-making. And this is an interesting topic, mainly because oftentimes, given the fact that the actions of the executive is now so extensive and comprehensive that they almost touch all facets of our lives, and we sometimes wonder, one, whether the executive would need specific legislative enactment or would need specific legislative authorization for it to do certain things, or whether or not there are certain things that the executive could do on its own, perhaps on the basis of what is known as its residual powers or its reserve powers. And we would also like to know if there might be limits to what the executive can do. Would it, for example, be sufficient that the executive can count upon a specific legislation passed by the Commonwealth which authorizes it to interfere, for example, with the rights of its citizens? And would that then become some kind of a carte blanche or an umbrella authorization that would allow it to do anything that the legislation allows? So, for example, what if there is a piece of legislation which allows, for example, the police to enter the premises of any citizen based on what? A mere anonymous phone call that it may receive from another citizen? Would it be permitted to just intrude into the premises of its citizens? Or let's say in the United States now, hold on, maybe I should stop sharing the screen for now. Or for example, in the United States, you may have come across stories where, how do they call it? Let's see. There are instances where people play jokes on fellow citizens or friends, or it may be playing jokes on celebrities, where they would say that at this specific address, we've heard a gunshot, and there's some cries for help, and requesting for the police to enter the property to rescue somebody. And on the basis of that anonymous phone call, would it be sufficient, for example, for the police to just barge in, even destroy the door, with arms and weapons cocked and ready for the purpose of helping somebody? So this has been going on in the United States, and sometimes it's out of fun. And so there's a lot of the Queensland VLAD laws, for example. So there are a lot of ways by which rights of citizens can be impacted, and it is sometimes crucial to determine, what are the constraints, what are the limits of executive action, and what are there limits to what the courts can do? And for those of you who grew up with James Bond in the movies, and I don't know how many of you are still quite familiar with James Bond, but you've oftentimes hear of stories like with a license to kill, and would there really be such a thing as a license to kill? I mean, it's recognized in common law that the police do have a license to kill in certain situations, maybe out of defense, out of self-defense, or if it might be necessary to protect the lives of innocent civilians. So the common law, meaning the courts, recognize that there is that inherent power of the police to kill for the purpose of securing the peace and welfare of its citizens. But how about the idea of a license to kill of spies? They may be permitted to either operate within Australia or permitted to operate abroad. Would that license to kill actually be legal? So these are some of the questions that we hope to look into as we study the topic of unauthorized decision making.
Mejo?
Yes, Patrick.
Would the example of the rules of engagement given to members of defence when they're up in operations, how they govern, how they determine when or not to use a weapon against the enemy or not, would that be an example?
Yes, that would be an example. That's right. The thing is, in relation to the armed forces, I would imagine that those rules of engagement would actually relate to the operation of the operation outside of Australia. So it would be the federal police or the state police that would typically be involved in operations within Australia. But those are some of the examples that we need to look into. Are there constraints and limits to what they can do? And would the courts actually be in a position to intervene if they feel that there is so much encroachment upon the fundamental rights and freedoms of its citizens? So it's an interesting topic, which is worth examining. And so Janet was pointing out the radio station hosts and the NERSIG and the UK. Yeah, and you're referring, I suppose, to that instance when one of the radio hosts imitate or try to pass herself off as the queen in order to try to determine, try to reach, to get in touch with Kate Middleton, I think, who at that time was in the hospital to give birth. Yeah, I mean, those types of things. What power does the executive have to impose constraints either on the radio station or even on individuals or radio hosts? Would it, for example, would the executive be required, for example, to have a specific enabling act coming from the Commonwealth to restrict radio hosts in their activities? So these are some of the typical questions that arise in relation to administrative law, and that's the topic that we're looking at in Chapter 5. But before we go there, was there anything you may have wanted to raise or questions you might want to ask? None? The one thing that I find surprising is that, I'm not very happy about, is the fact that there seemed to be very limited engagement of students, both in the Zoom sessions and in the discussion questions. I wonder where the students are. It's different from what I'm experiencing in constitutional law, because the participation rates both in the Zoom tutorials as well as in the discussion questions are quite high. But in our administrative law course, we have very few students attending the Zoom sessions, and I would often see very few students actually putting in their answers in the discussion questions, and I wonder what's going on. Would you have an idea? No, because you would be the ones who are.
Yep. No.
Yeah?
No, Jackie's not here tonight because she's got something else on.
Yeah.
But she's also got mandatory attendance at another tutorial. I think I'm not sure which subject it is, but I know she mentioned it before.
I see. It's actually mandatory for her to join.
Yes, it is. Yeah, they're both, yours and the other subject are mandatory.
Ours is not mandatory. You know, it's an optional thing. You can be here. You don't have to be here. The important thing is you could engage in the group discussion through the discussion questions. So I think that would be one.
That's the only thing that I've heard.
Okay.
I don't know. Yeah.
Okay, there's so much that I could do, so we'll just proceed. Yeah, but you're right. I think there must be 3 or 4 shoots running at the same time tonight. Okay, so let's proceed with the discussion. So I'm gonna start to share the screen. So in terms of the learning outcomes for tonight, we hope that after tonight's session, you should then be able to discuss and explain whether legal authority is required for every executive decision or action to be made. And you should then also be able to discuss and explain unauthorized decision-making and the types of executive decisions and actions that do not require specific legal authority. So, okay, that's fine, Janet. So the thing is, when you think about it, this specific topic has a lot of relevance to us because we would like to know, what are the constraints to executive action and decision making, and up to what extent is the executive actually allowed to interfere with our lives, and up to what extent can we make decisions. So that's the purpose of tonight's topic. So we will begin by talking about and trying to answer discussion question 1. Patrick, if you could,
yes.
Do you mind reading discussion question 1 for us?
I can do that.
Yeah.
Judicial review is said to be of limited scope that focuses on the process of decision-making, observance of fairness, procedural fairness, and natural justice, and not on the decision itself. In what circumstances is judicial review said to involve a review of the decision itself?
Okay. I'll give you about a minute to think about that. And then perhaps if you're ready, you could just type your answers in the chat box. Okay. So we're just gonna put it on the screen. Okay, good. Hold on. When a decision is running the risk of being ultra vires, when the decision is of a judicial nature, it is an error of law, or whether the decision was an error of law within the scope of the power provided, breach of law, ultra vires. Okay. Yeah, it's possible that the question is a bit vague. It's possible. What I was trying to hint at was that if you look at, if you examine the type of decisions that the courts will not touch, these types of decisions are those which involve issues about factual correctness. So it's not about the issue of legality. So if it's a question of the correctness of a decision, courts would veer away from it, because to the courts, the only time when they would intervene or interfere with an executive decision is when it involves a question of legality or lawfulness of a decision. So it wouldn't look into the correctness of a decision. When we speak of a correctness of a decision, we are making an assumption that the courts will not examine the reasons behind the decisions, because the reasons behind the decisions would often involve the merits of a decision. And as we said, if you look at judicial review is limited to the legality or the lawfulness of a decision. So either the courts will only examine the legality of the decision, meaning whether it's in accordance with law, or examine the process of decision making itself, whether procedural fairness was observed or whether natural justice was observed. But it will not examine the merit itself of the decision, the merit being, the reason behind the decision, because that often goes into the correctness of a decision. So the courts have been clear in saying that it is not for them to look into the merits of a decision, because that is for best left to administrative bodies to look into, because the power of courts is limited only to the issue of legality or the lawfulness of executive decisions. But there is an instance when, to one extent, you might be able to say that the courts actually go beyond the issue of legality. They don't just look at the issue of lawfulness, although it's actually connected to the issue of lawfulness. There are times when they actually kind of look into the merits or the reasons of a decision. And that is when they feel that the decision made by an executive decision maker is so unreasonable that they feel that there is no body or no reasonable authority who would be able to arrive at that decision. So this is what they call witness-bearing unreasonableness. Yes, Janet? The notion of witness-bearing unreasonableness. So when the decision is so unreasonable that there is no reasonable authority or body that would arrive at that decision, then the courts will be prepared to step in. Okay? And in that case, although we say that the courts intervene because the decision would be deemed unlawful, to a great extent, the basis of the court's intervention would actually would not be directly because it is contrary to law, but because the decision itself is unreasonable. So that looks somehow into the correctness or even the merits of the decision, but there is really no basis. There is no basis for the decision and it's just so unreasonable. And because it is so unreasonable, then it becomes unlawful. But it is not on the basis straight away that it is contrary to law that would sustain the intervention of the courts. Okay, so that's witness-bearing reasonableness. Clear so far? Questions there? Was that clear enough?
It's clear.
Okay, thank you. So we will proceed. So the other statements here, let's say when we say that there's a risk of being ultra vires, that goes straight away to the issue of unlawfulness. That's quite clear, because if it's beyond authority, then that's ultra vires. It's definitely contrary to law. When there is an error of law, obviously that again talks about being an unlawful or illegal decision. So the reason, in that case, the intervention of the court is on the basis still of legality or lawfulness of the decision. But the witness-bearing reasonableness somehow looks into the reason or the merits of the decision itself, because it is so unreasonable that it becomes unlawful. Okay, so let's proceed to discussion question 2. Patrick, can I ask you again if it's okay to read discussion question 2?
Yes. The Minister of Health created a health awareness program that provided a budget of $20 million for a program to promote awareness of men's depression as a health issue. Red Manson asserts that the program is rubbish and has called on the minister to withdraw the funding, claiming that the money is better spent on other programs in the current economic environment. He also asserts that the minister has no legal authority to make the budgetary decision. When the minister refused to revoke his decision, Manson considered filing an application for judicial review on the ground that the decision is unauthorised. He has come to you as solicitor. What would you advise him?
Thank you, Patrick. So let's think about this for a moment. Okay. And if you're ready, if you could, again, just type in the chat box. What would your advice be to Mr. Manson? Would there be a basis to apply for judicial review? Okay, so from Josh, Patrick, would you like to try and answer there?
I'll just put one up.
Okay, thank you. Okay, let's see. Okay, before we go to standing for judicial review, that's a good point. I just want to explore this idea about, was this discretionary funding by the minister? If so, then there is no possibility of judicial review. And that would be from Janet. Janet, are you able to explain that?
If it's discretionary funding by the minister, unless there is some sort of other legal precedent or constitutional reason, I'm not doing constitutional law yet, I cannot see why a judicial review would be the appropriate way to go. It's discretionary, it's by the minister, legislation trumps all else. This isn't legislation, but it's still part of the legislature. I guess that's where I'm coming from.
Okay, thank you. That's a very valid point, because as we've probably discussed in the previous weeks, if a decision is based on policy considerations or is based on discretions, so therefore that goes to the merits of a decision, then courts will not interfere. So that's going to be one ground. This is discretionary, and so therefore that does not involve issues of legality. There's nothing about it being against the law. So discretion allows an executive within certain parameters or within certain policy guidelines to decide matters either way. And it is not for the courts to determine, how the discretion is meant to be exercised. Because remember, the scope of, so thank you, Janet, this is very good. Remember, the scope of judicial review is very limited in the sense that judicial review is not permitted to, so a court in exercising judicial review is not permitted to change or vary the decision of an executive decision maker. That is only possible in the scope in terms of an administrative review. The role of courts is either to affirm the decision that it is legal, or it can quash the decision, meaning it can set it aside. But it is not for the courts to say that this is the proper decision that should have been made. So, and especially in the context of this, if it's discretionary, as Janet pointed out, as far as discretion is concerned, it actually means that it is up to the executive to decide one way or the other. And that is something that cannot be controlled by the courts unless in the exercise of the discretion, the decision maker did not follow the guidelines. So if the minister did not follow the guidelines or the aims or the policies behind the legislation, then in that case, that can be unlawful. So the decision making would have been unlawful. But the mere exercise of the discretion itself is something that courts will not interfere with. Okay? So thank you, Janet. That was very good. Now, the other point was the decision may only be unreasonable if there was an error of law. Okay, so the point there of Patrick is that a potential ground would have been the decision is very unreasonable, that it meets the requirements of Wednesbury unreasonableness, so that in that case, there is an error of law, but there doesn't seem to be anything so unreasonable about it, because especially if it relates to the exercise of discretion. So that's a good point. The decision does not interfere with the rights. Okay, so that point, Josh, what is the implication of that? When we say that because the decision does not interfere with the rights of anyone and is not coercive, then what?
Then it does not require statutory authority. It's authority that just goes with the office.
Right. Good. So that is a crucial point. But remember, I thought we talked about the principle of legality, Josh. Remember the principle of legality where we kind of heard that the executive can only act on the basis of a law authorizing it if it interferes with rights, although that seems to be the way it was stated, right?
Well, if it's not prohibited by law, then they can do it. And it's within the power of the minister to exercise his powers to run the country within the scope of his authority. And the principle of legality does not constrain his power to do that as a part of the legislature.
Okay, so that again is a one crucial point here, because we have to be very clear that as far as the members of the executive are concerned, especially the cabinet ministers, they do not require any specific legislation or enactment to authorize them to act in certain ways. The assumption here is that on the basis of the executive power given to the executive under the Constitution to execute the laws of the Commonwealth, for example, that provides with it enough authority to do what needs to be done. So it would be unthinkable to say that for the executive to ensure that laws of the Commonwealth are being implemented and being executed, that there is required a specific enactment coming from the Commonwealth. That would be absurd. Did I hear somebody saying something there? Oh, Paul has just joined us. Hello, Paul. Welcome. Were you wanting to contribute something or say something?
No, sorry, I just joined. I mistook the time. I thought it was 6:30, not 6 o'clock. So apologies for my lateness.
Not a problem. Yeah. Okay, that's fine. So that's crucial. The Constitution is quite clear in saying that the executive power is with the executive, and the assumption being, therefore, that constitutional provision of the Constitution is sufficient authorization for the executive to do what needs to be done without specific enactment coming from the Commonwealth legislature. In addition, there is such a thing as executive powers, which are based on residual powers of the Commonwealth or residual powers of the Crown. And these are inherent powers For example, the power to enter into treaties, the power to enter into contracts, the power to have diplomatic relations with other agencies, the power, for example, to create new government agencies belonging to the Commonwealth. These are meant to be inherent powers of the Crown or of the executive, and there is no requirement for any legislative enactment for the executive to be exercising its powers in this way. Now, the point, however, is that the moment when the executive exercises its powers and it interferes with the rights of persons, then in that case, the principle of legality will step in to ask on what legal basis, on what basis would the executive have for interfering with the rights and freedoms of certain individuals. And even when we try to respond to that question, it needs to be clear that as far as what kind of authorization is required in order for the executive to interfere with the rights and freedoms of individuals, that specific legal authorization is not limited to any statutory enactment. As I pointed out, it can be on the basis of the reserved powers of the executive or the reserved powers of the Crown. And in this particular case, for example,
yes, a question.
Go ahead.
There was a case a couple of years ago with the chaplains in the schools. I think it was Toowoomba based.
Yes.
There was a guy from Toowoomba who challenged now I'm not sure if that was discretionary funding, Prime Minister, for chaplains in the schools. I can't remember the intricacies of the case, but there was something a little bit like this. It was a little bit like this. Are you familiar with it?
I'm not sure. I arrived in Australia less than 2 years ago, but that's a good point. Oh, Andrew, sorry. I think I put it in my email that we would start at 6, and we now begin to start at 6, mainly because there is another class at 7. And I happen to be sharing the license with that next class. So we used to be using Blackboard Collaborate, but we no longer do. And as a result, we have to use a shared license. And we've had a number of problems starting last week. We've been emailing each other, the lecturers, because the lecturers of one would end up kind of getting cut off. So yeah, I made the announcement in the email that the Zoom session would begin at 6, and that is the kind of schedule we will be following, even in the succeeding weeks. Yeah, so that's at 6 now. But Janet raises a good point. So we'll assume that, as you pointed out, it was a decision of the Prime Minister providing funding for a particular chaplaincy in Toowoomba. So let's assume that, which is kind of related to this. And again, I'm hoping I'm not digressing too much yet. Yep. Okay, good. So, Janet, would you remember if it was brought before the courts? Would you remember what the decision was?
Yes, it did. It went before the courts, and if my computer was a little bit better, I'd actually look it up because I kept the information. And I thought, but don't quote me on it, that there was some validity to the complaint made. I'm not sure what the outcome was. Someone else here may be able to just add a little bit more information to it. I'd need to relook at it to see what it was, but it was something to do with the Constitution, something to do with the federal government funding chaplains in schools, in state schools, and yeah, that's about it as far as memory goes.
Okay, Andrew, would you be familiar with the case? Because I'm not. I could speculate on... Yeah?
Only a little bit. I think it was alleged that there was a breach under Section 61 of the Constitution about executive prerogative and spending. I don't remember the outcome though. Sorry, I don't remember the outcome.
Okay.
I remember the case.
Yeah. But there is a question there. There is a key point that is relevant to administrative law and which is kind of relevant to one of the issues here in discussion question 2. would there be a legal basis to challenge a decision of a minister or a decision of the prime minister to fund certain programs in a certain way, which in a sense is obviously discriminatory, because when you fund, when you have a funding program, it's typically good for one set of demographics, a set of people, but not good for the other. So it benefits one group of people, but not another. So that in that sense, it can be discriminatory. Had standing to challenge the validity of the funding agreement. Okay, good. But what was the decision then? Okay, good. Okay, so it would seem, and that was my suspicion. The reason, thank you for that. That came from Josh. If you go by Section 61 of the Constitution, therefore, the reference was whether or not it was within the power of the Commonwealth to enact legislation in this regard. So, in other words, but this is not something that we discuss in administrative law. Okay. So, if we were to discuss this in the context of constitutional law, the federal government or the Commonwealth Parliament can actually enact legislation only according to what is explicitly provided or expressly provided in the Commonwealth Constitution. Beyond those powers, beyond those subjects, it is within the scope of state parliaments to legislate. And so therefore, in those areas where the Constitution has not given the Commonwealth Parliament the authority to legislate, meaning it is not covered by Section 61, for example, of the Constitution, or rather Section 51 of the Constitution. What it therefore means is that that subject or head of power would then belong exclusively to the states. So I think I haven't seen this specific, I haven't seen. Okay, that's fine, Josh. I just amazing when you say, sorry, imagine mom just called me. So it just tells you how young you are. Okay, that's fine. Yeah. Okay, thank you, Josh. So I would imagine that the reasoning would be because it is not within the head of power of the Commonwealth Parliament to legislate on, because education actually belongs to the state, belongs to the state parliaments to legislate on, because it is not within among the matters that are found in Section 51. Okay, thank you, Josh. Under Section 51 of the Constitution. Now, I'm digressing. But briefly, before we end up digressing too much, briefly, it would have been possible if the state parliaments, for example, a state parliament or all state parliaments would authorize the Commonwealth Parliament to legislate on a matter that should have been exclusively within the realm of the state parliaments to legislate. That again is permissible under the provisions of the Constitution. But otherwise, there are certain subject areas or heads of power that belong exclusively to the states and which the Commonwealth Parliament cannot legislate upon. Because as I said, just to summarize, the Commonwealth Parliament can only legislate on those subjects that are expressly provided for under Section 51 of the Constitution and other headings such as where the seat of Parliament should be and so on. Now, but backtracking a bit to the issue of administrative law, that question of the Prime Minister or a Minister of the Cabinet authorizing payments in a certain way, okay? Assuming that there is a Commonwealth law, for example, that authorizes the minister to allocate funds in a certain way. The question is, could there be a basis for judicial review in the way that a minister may decide to allocate funds? Would there be a ground for judicial review in that specific case? And that is one of those things that we're trying to, that's one of the legal issues that we're hoping to address actually in discussion question 2. What do you think?
Can you just repeat that, please?
So let me repeat that. Let's assume that the Prime Minister in the Toowoomba case or a Minister of the Cabinet allocates funds for a specific program or for a specific set of persons. The question is, let's assume that there is a person with legal standing who is affected by that allocation of funds, who complains about the way that the funds were allocated. And he's saying, why are you allocating the funds to this group of persons or to these programs and not to me? The question is, would there be a basis for a judicial review when the Prime Minister or a cabinet minister allocates funds in a certain way? Would there be a basis, a legal ground for judicial review?
Man, Joe, there must be, because that case highlights that Williams and Commonwealth case went to the High Court. So straight away, there's evidence there that those cases do have judicial review.
Yeah, okay, good. Now, we have to be very careful that we don't, I haven't read the case, but we have to be very careful from what we take away from the case that Janet cited, because as a general principle, the kind of example I gave, and which is the one which is also included in discussion question 2, where a minister may allocate funds in a certain way that actually involves a political decision. And because it involves a political decision, that is what is known as a non-justiciable question. Courts will not step in to correct or to examine the legality of political decisions, because they would say that the elected representatives, and that would be the members of the executive or the members of the legislature, they are the persons who are in the best position to determine how to allocate funds. So that would be a political decision, and this is clearly supported by the case of Minister of Arts, Heritage, and Environment versus Pecco Wolson. That would be a decision that would clearly state the principle that the courts will not intervene to exercise its power of judicial review when a decision of the executive involves a political decision, because that is non-justiciable. Now, the only reason why, and I haven't read the case as I said, the only reason why perhaps going to that case cited by Janet, the Toowoomba thing, where the High Court intervened, was because that involved a constitutional question. The power of the High Court on the basis of Section 75 of the Australian Commonwealth was presumably triggered because that involved a suit against the Commonwealth or a minister of the Commonwealth. And the constitutional question there then would be whether or not the Commonwealth minister or the Commonwealth Prime Minister had the power to act in the area of education, assuming that there was an enactment coming from the Commonwealth Parliament relating to education. Because, as I pointed out, education is not one of those subjects or heads of power that Section 51 has granted to the Commonwealth Parliament. And for that reason, education is exclusively, as a subject, is exclusively for the state parliaments to decide and not for the Commonwealth Parliament. So that, I think, would have been the reason why the High Court intervened here, that it was a matter that was left solely for the state parliaments to determine. And therefore, to an extent, the Commonwealth Parliament, and perhaps if there was a legislation here, or maybe even the executive, Commonwealth executive, may have intruded into a subject that belonged exclusively to the states. I would imagine that would have been the reasoning, but I haven't seen the case. Okay, but I'm just drawing on basic constitutional law principles as well. Okay, questions so far? So we're clear. So there would be 3 reasons. So if we summarize, there would be 3 reasons why, if I were the solicitor, I would tell Mr. Manson that there is not enough basis for him to ask for a judicial review. The first is that he doesn't have any legal standing. He doesn't have any special interest in the way that the budget has been allocated. It doesn't affect him in particular. And for there to be locus standi, it is necessary that any action of the executive must have a specific impact or effect on the party litigant or on the applicant. So there's no locus standi. The second reason would be that the issue is actually non-justiciable because the issue of how funds should be allocated is a political decision. So it is not ripe for judicial review. I mean, it is not appropriate or apt for judicial review because it involves a political question and therefore non-justiciable. The third is, if the claim of Mr. Manson was that there was no specific legal authority, whether by enactment, for example, that authorized the Minister of Health to act in a certain way, under the principle of legality, there is no requirement that the executive has to act solely on the basis of a specific legislative enactment in order to act in a certain way. The Commonwealth Constitution would be sufficient authority for the executive to act and to execute the laws of the Commonwealth, or to make sure that the Commonwealth operates and all its services are properly undertaken. That would be sufficient. Or two, the executive department actually has its own reserve powers, which then authorizes the executive to act. So this could be about setting up agencies, entering into contracts. There is no need for a legislative enactment for the executive to act in these areas because of the principle of certain reserve powers. So these are powers which are inherent in the executive. Okay, clear so far there? So 3 reasons. So we will move on. Okay. Okay, so we'll go to question 3, which is kind of, yeah. So we've discussed this in relation to question 2. What does the principle of legality mean? Does it mean that every executive decision, in order to be lawful, must be supported by a specific legal authority that authorizes that decision? And the answer is no. Okay, there is no need for a specific legal authority, meaning an enactment from Parliament, from the Commonwealth Parliament. There is no need for that. Under the principle of legality, what it only means is that only in those instances when the actions of the executive may interfere with the rights and freedoms of individuals, may there be a requirement to ask whether or not there was a specific legal authority for the executive to act in a certain way. That specific legal authority may actually be in the form of an enactment coming from the Commonwealth Parliament, or it could be on the basis of the reserve powers of the Commonwealth. Okay? But otherwise, if the executive ends up making a decision, there is no requirement that there must be a specific statutory, meaning a legal enactment coming from the Commonwealth that has to support that decision by the executive. That is not necessary. So that's just kind of repeating what we discussed in discussion question 2. So we will go to question number 4, and perhaps I could again ask Patrick to read discussion question 4 for us. If Patrick, if you're still there?
Yes, yes. Claiming broad powers under the Australian National Security Act, Commonwealth, the Australian Security Intelligence Organisation, ASIO, Director General of Security, ordered the arrest and detention for a period of 90 days of Jameson Ibrahim, an Australian citizen who was alleged to have recently committed atrocities in Syria. Ibrahim's solicitor filed an application with the Federal Court of Australia for judicial review of the legality of his continuing detention. The ASIO Director General of Security asserts that the detention is legal since it is authorised by the Australian National Security Act, Commonwealth, that provides that the ASIO Director General of Security may cause the arrest and detention for a period not exceeding 120 days of any person who he considers on the proper evaluation to be a threat to national security. Advise on the validity of the ASIO Director General of Security's argument.
Okay, let's think about that for a minute. And then if you could, in about a minute, provide your answers in the chat box. So we've got an answer from Andrew here. Hold on. So from Janet, same as Andrew. Patrick, would you like to hazard a guess? Okay, rights of citizenship. Okay, where do we begin? Patrick, if it's okay, would you mind explaining your answer? Patrick, if it's okay?
Yeah, I'll try. Yeah, I'll try and explain the best I can. I think because citizenship is a liberty, and if you take it away because the Constitution says you can't take citizenship away, so that's sort of my idea of it.
Sorry,
Okay.
Manjo, it's Paul.
Paul, yes.
The question's not about citizenship, though. It's more about detention whilst, investigations and review. So it's removing liberty, sure, but at the moment it's not a question of citizenship. He hasn't been found guilty. What they want to question is the legality of being able to detain a citizen without legal process having taken place, which I agree, that's open to a judicial review because you can review the legislation. But what the DG did was in accordance with legislation, which is the law.
Okay, good point. So that was nice. What Paul did was to do a two-step process. So he was saying that this can be the subject of judicial review. Very good. So either on the basis of the Administrative Decisions Judicial Review Act of 1977, it is possible for there to be judicial review of this decision, for example, because it was saying that the decision was based on a clear enactment, which is the Australian National Security Act. Or it could even be on the basis of Section 39B of the Judiciary Act of 1903 Commonwealth, which does authorize the Federal Court of Australia to exercise its power of judicial review in relation to officers of the Commonwealth, which is a comparable provision to Section 75 of the Commonwealth Constitution, because Section 75 of the Commonwealth Constitution refers to the power of the High Court. Section 39B of the Judiciary Act of 1903 Commonwealth refers to the powers of the Federal Court of Australia. So that's correct. The first step of the process is, would there be a ground for judicial review? The answer is yes. Now, assuming that the Federal Court of Australia actually accepts this application and exercises its power of judicial review, in what way is the Federal Court of Australia likely to rule? Is it likely to validate the act of the ACO Director General, or will it say that the act of the ACO Director General is unlawful? So that's the second question. Okay, what do you think is the answer? So we have hurdled the first requirement. We agree that there is a basis for judicial review. Fine. The second question is, how do you think is the Federal Court of Australia likely to decide on the question of the action of the ACO Director General of Security? Will it say that the acts of the ACO Director General are valid, or will the Federal Court of Australia say that the acts of the ACO Director General are invalid? Can I just see on the chat box whether you think that the FCA will say they're valid or not valid? So from Andrew, valid. From the others, there are only 4 of you. From Paul, valid. Valid from Patrick. Janet.
I'm just going back and looking at the questions. Sorry, I'm a little bit busy, guys. You said there's a ground for judicial review under legality.
Yep.
I don't see that there is.
So what are you saying? Is it valid or not valid?
It's valid. It's in accordance with the Act, but I'm still not seeing why there's a ground for judicial review under legality.
Oh, you're going back to the first issue, why there is a ground for a judicial review.
Yeah.
There is a ground for judicial review because they're questioning the lawfulness of the decision of the Director General to
So it's only the decision of the Director General, not the Act itself.
At this point, we're just looking at the, well, as a corollary matter, it is possible that the constitutionality of the Act may be questioned, but in this case, as in relation, the focus of the question is on the actions of the ASIO Director General itself, whether his acts would be valid. And that is, it's possible for judicial review of the courts to be exercised either on the basis of the Administrative Judicial Decisions Review Act of 1977, because the actions of the ASIO Director General were decisions based on an enactment, which is the Australian National Security Act, Commonwealth, or it could also be based on Section 39B of the 1903 Judiciary Act of 1903 Commonwealth, which authorizes the Federal Court of Australia to act, to issue writs of prohibition, mandamus, or injunction in relation to officers of the Commonwealth. And the ASIO Director General is an officer of the Commonwealth. So there would be basis for judicial review. The question, however, the question I asked was, would it be valid? Do you suppose that the Federal Court of Australia will end up saying that the ASIO Director General acted lawfully because he acted on the basis of a specific enactment of the Commonwealth of Australia? And the answer, your answers would be yes. And you say yes because there is a law, that's a specific law that authorizes the ASIO Director General to act in a certain way. Now, let me put this further. Okay, just for you to examine, the logic there. What if the Australian National Security Act authorized the ASIO Director General to arrest and detain a person under the same circumstances for a period of, let's say, 1 year? Would that be valid or not? Let me repeat. Assuming that the Australian National Security Act authorizes the ASIO Director General to arrest and detain a person for a period of 1 year, if the ASIO Director General has sufficient grounds and that to believe that an Australian citizen is committing a serious crime, for example, or committed atrocities in Syria, would it mean that the act of the Minister or the Director General would be valid because it is authorized by a Commonwealth legislation?
Manjo, this
yes.
is you'll see that Paul and I are discussing this in the text box in relation to the difference between this and somebody being remanded in custody after a charge and not yet found guilty, obviously. In this case, are you saying that this person has been arrested and charged by the Director General, so he will end up in court for that offence, or are you just saying that the Director General's just decided to keep this bloke in custody, no charge, no actual plan to take him in front of a court for a period of up to 12 months?
My answer would be, would it matter? Would it make a difference?
Well,
on the one hand,
I think
go ahead.
I think it would make a difference because certainly holding somebody in remand on the pretext that they're yet to go to court would be a legitimate thing, depending on the offence that they've been accused of. Yep. But I think just holding somebody for 12 months with no chance or no plan to actually take them to court for the alleged offence that gives them no avenue, or right of appeal, I think would just be holding somebody basically illegally.
Yep. Let's assume that they're on remand, meaning a complaint has been filed in court, but the court is yet to act on it. So in other words, the decision to keep a person in detention for a period of 12 months is solely on the basis of a decision of the executive, let's say the ASIO Director General. And assuming that is authorized by a specific act of parliament, would that be valid?
It's no different to state-based remand then, is it?
Is there a difference or not? What do you think?
Not one that's jumping out, but I'm sure there is one that you're going to tell me.
Yes, I am. Okay.
It impacts on the individual, on an individual. That's the first thing.
Say it, Janet?
So it impacts on an individual. That's the first thing.
Yeah.
It goes beyond the scope of the legislation that's written in the discussion question 19.
Yeah, but I was expanding the bigger, I was going to, because everyone said it's valid, and we're trying to check if, you actually believe that your answers might be correct. And I was giving the example whereby, what if a law, an enactment of parliament actually authorizes the executive, let's say, or even the police, to detain somebody without charge for a period of 1 year. And that there is legislation which specifically authorizes that. Would that then validate the act? Yeah, without charge, definitely. So whether it's 120 days or what if it's 6 months? What if it were 6 months? Would that be valid, assuming that it's authorized by legislation? Would that be valid? Because remember, you're saying it's valid because there is a law which authorizes it. So does it mean that if a law authorizes it, therefore the act of the executive is valid? So what if there is a law which says, passed by Parliament, which says, Commonwealth Parliament, which says that it is legal for a member of the Australian Defence Force to kill innocent civilians in some other countries. Would that be valid? Oh, okay. Yeah, we might get disconnected. The point is, the answer is, this is likely to be invalid. Okay? The mere fact that there is an enabling legislation or there is an enactment which authorizes the executive does not mean that the executive, therefore, can do whatever the enactment authorizes. The enactment itself can actually be questioned. And the specific case you will have to look at, and I'm not sure if I put it in the lecture notes, is A versus Hayden, number 2, 1984, 156 CLR 532, where it is within the power of the court still to look into the legality of the law itself, testing it in relation to whether or not the detention or the arrest might be so oppressive as to go against fundamental freedoms that are deemed to be essential to a democracy. So just in other words, there are limits to what the Commonwealth Parliament can enact, even for the purpose of defending the Commonwealth. There are limits to what it can do. And in other words, it is not permissible for the executive to just do anything for as long as there is a Commonwealth Parliament act or statute that authorizes it. There are limits to what the Commonwealth Parliament can authorize the executive to do. And this might be one of those instances, because a period of 90 days or even a period of 120 days may be a bit too excessive. It cannot be justified. Now, the issue about remand is different, because if a person is incarcerated on remand, there is a possibility that the basis of the continuing detention would have been would have been a decision of the court, not a decision of the executive himself or herself. So there's a distinction there. If it is the court which orders the continuing detention, then that can be indefinite, because that is a decision of the court. But for the executive to, on its own, decide on an indefinite detention, even on the basis of a Commonwealth legislation, that is totally something else. That is different. Okay, before we end tonight's session, do we have any questions, comments? So think about that, because we don't want you thinking that, the executive can do anything that it likes simply because there is a law passed by Parliament that authorizes it. That is not sufficient if you go by the case of A versus Hayden, number 2. Questions, comments before we end tonight's session? Is this week the end of the first 50%? I think we have until next week. We have until next week, yeah. Okay, good. So we're good. Thank you, everyone, for joining us. And please remember that in the future, we will meet at 6 o'clock consistently. Okay, so thank you, everyone, and I hope to see you next week. Good night. Bye.